Thanks very much, David, and to you and the committee. I'm very grateful for the honour of being invited to come and speak at the Northern Branch today. This is an august institution, and the motive to advance knowledge is, of course, one that resonates deeply with me. As an academic for 40 years, I've been all about the advancement of knowledge through teaching and through research, and also, in my case, through the practice of this fairly narrow body of international law, the law of war, the law of armed conflict, international humanitarian law, all synonyms. But I'm prepared to say today that that particular body of law has never been more important or more relevant. And if you, like me, think the world has gone crazy in the last few years, I'm certainly with you on that. Let me just say that I don't want you to turn up on Sunday, March the 25th, for the AGM of the Royal Society of Tasmania Northern Branch, because this year, Sunday's the 24th. Normally, in every other year, we know that the days and the dates in March follow the days and the dates in February, because February only has 28 days. But in an Olympic year, that extra day throws us out a little bit, doesn't it? So I'm pretty sure it's Sunday the 24th.
It is.
Yeah. Not Monday the 25th. Please excuse me for the pedantry that picked that up, but just thought it shouldn't go unnoticed. Sounded a bit like a eulogy to me. I'm glad I'm still here with that introduction, but I just want you to know that despite the role that I have in The Hague, next week will be my 14th year as Special Advisor on War Crimes to the Prosecutor of the International Criminal Court. I'm speaking very much in my personal capacity. I don't have the authority of the Prosecutor to speak on his behalf to you on this topic. You'll understand, of course, that some things are confidential that I'm privy to, and I won't be disclosing any of those. But I want you to know that it's very much in my personal capacity. I thought it might help if I talked a little bit about the background to what this institution is, the International Criminal Court, the other ICC, some might say. And here, unscripted, but also for me, I have an inability to avoid telling this story, a little story about the other ICC. On the day, 1st of March 2010, that my appointment to the International Criminal Court was announced. It was also announced in this country that the former Prime Minister of Australia, John Howard, had been nominated to be the Vice President of the International Cricket Council. It will come as no surprise to any of you that the media in this country plastered one of those stories everywhere, and the other story, at best, was relegated to news in brief in the few outlets that chose to report it. However, only one of us was appointed to the role, and I'm happy with that. I will use the acronym ICC from here on in probably, but I'm not talking about the Cricket Council, I'm talking about the International Criminal Court. The principle of individual criminal responsibility for violations of international crimes was established at Nuremberg and Tokyo in the war crimes trials in the immediate aftermath of World War II. That the Allies established to impose justice on the senior military, political and economic leadership of defeated Nazi Germany in Nuremberg and the defeated Japanese in Tokyo. And the principle, despite all the criticisms of victor's justice, of the winning side imposing a system of justice on the losers, despite all the criticisms of those two trials, that principle has been unassailable ever since. At Nuremberg, the International Military Tribunal famously said, amongst many other things, crimes against international law are committed by men not by abstract entities. And only by punishing individuals who commit such crimes can the provisions of international law be enforced. The International Criminal Court is, in one sense, a natural progression of the process that was initiated at the Nuremberg and Tokyo war crimes trials. I think I'd talk about, many scholars with me of international criminal law would talk about Nuremberg and Tokyo as international criminal law 1.0, the first sort of iteration. The model has now been discredited of only one side imposing justice on the other. We've seen in the early 1990s, 45 years after judgment was handed down in Tokyo in 1948, in 1993 the UN Security Council established the International Criminal Tribunal for the former Yugoslavia. David mentioned that I had the privilege of being involved in the Milosevic trial under the auspices of that institution. 1994, the following year, the tribunal established the International Criminal Tribunal for Rwanda. This is International Criminal Law 2.0, if you like, an advance on the model of Nuremberg and Tokyo, because this time these tribunals were set up by the Security Council on behalf of the international community, involving the imposition of justice on individuals from all sides of the respective conflicts in the Balkans and in Rwanda. But the tribunals were ad hoc. They were established for those specific situations. And if it's good enough to have a tribunal for the former Yugoslavia or for Rwanda, why not also for neighbouring Burundi or Zimbabwe, or outside of Africa for Romania, for East Timor, for Cambodia, for El Salvador, for any other conflict situation in the world. So there's a sense in which the International Criminal Court, the ICC, is representative of International Criminal Law 3.0. This is an advance again, this time creating a permanent International Criminal Court, not a court ad hoc for a specific conflict, but a court with, at least in theory, the potential to try international crimes wherever they occur in the world. Now, that's a sense in which the ICC is a natural progression in terms of what's gone before. But there's also a sense in which it really challenges state sovereignty in ways that nothing that preceded it ever did. And it's important to also capture that. And we'll come on to talk a little bit about the sensitivities of how it is that the International Criminal Court has jurisdiction in Georgia or in Ukraine, despite the fact that Russia is not a state party. How the International Criminal Court has jurisdiction in Afghanistan, despite the fact that the US is not a state party. And of course in Palestine, despite the fact that Israel is not a state party. When the court was established, and I had the privilege for 2 of the 5 weeks of the diplomatic conference in Rome in 1998, you can imagine shocking place to have to spend 5 weeks for a diplomatic conference. I was there for 2 weeks with the Australian government delegation, and everybody there had a sense of the historic significance of what was being achieved after midnight on the final day of the 5-week conference, when the president of the diplomatic conference banged his gavel to say the Rome Statute for the International Criminal Court is adopted. In alphabetical order, Australia sits between Argentina and Austria. The Argentinians were dancing on the tables, as you'd expect. Australia was sort of somewhere in between. To our right, Austria, the head of the Austrian delegation was seen to crack a smile. And honestly, that is a significant breakthrough in multilateral affairs, possibly less regular than claimed sightings of your beautiful emblem, the thylacine itself. I'm not sure about that, but everybody understood that the International Criminal Court was being created as a way of challenging impunity for atrocity, that those responsible for perpetrating international crimes would now know that they faced international scrutiny for their conduct and may well be tried for their crimes. So let me explain a few things about what the ICC is. I said before, it is the world's first permanent international criminal tribunal. There are 123 states parties from all regions of the world. That's not quite 2/3 of the world's sovereign nation states. And that state party list does not include the US, Russia or China. Talk some more about that a little bit later on. But it's nevertheless a very significant group of states parties. And amongst those states, 18 judges are elected for 9-year terms. We don't have a wholesale election to remove 18 after 9 years. It's a little bit like a half Senate election. It's a sort of a third of the judicial body election every 3 years. So each 3 years, another 6 judges are elected for 9 years. And that means at any particular given time, 12 of the 18 judges have had some experience on the court. This court has jurisdiction over 4 categories of crime. Genocide, defined in Article 6, with a verbatim replication of the 1948 UN Convention on the Prevention and Punishment of the Crime of Genocide as the definition. Article 7, crimes against humanity, with a more extensive list of those acts which can constitute a crime against humanity than anything that's ever preceded the Rome Statute. Article 8, the provision that is my not quite daily focus, but at the moment, with all that's going on in Gaza and Ukraine, weekly focus. Article 8 defines war crimes. And Article 8b, or 8 bis, take the Latin abbreviation for B, we have the crime of aggression. And the reason it's 8b and not 9 is because it was not included in 1998 when the Rome Statute was first negotiated and was added at the first review conference for the Rome Statute in Kampala, Uganda in 2010. How does a case actually come to the court? Let me make a few observations about that, all preliminary to our discussion and focus on the Ukraine and Gaza situations. There are 3 requirements for a case coming to the court, and the first of them is a requirement of consent. The court cannot decide a case unless one of either the territorial state, the sovereign nation state on whose physical territory the alleged crime has occurred, or the state of nationality, the state whose national allegedly perpetrated the offence. One of those 2 states must consent to the court's jurisdiction, or else the court has no authority to act. There's one exception to that, and that is if the UN Security Council refers a matter to the court, which it has the authority to do even without the consent of either the territorial state or the state of nationality. So we have 2 situations before the court in relation to Darfur in the west of Sudan, and also Libya, where the UN Security Council referred both situations to the Prosecutor of the International Criminal Court, and in so doing, acting under Chapter 7 of the UN Charter, in situations where neither Sudan nor Libya were states parties to the statute, the Security Council overrode the requirement of consent because of the constitutional authority that it has under the UN Charter. There are 2 ways that either the territorial state or the state of nationality can express their consent. One of those is if either of them is a state party to the statute, because when you sign up to the statute, you are deemed to have consented to the court's exercise of jurisdiction. That sort of makes sense, doesn't it? The alternative, if either of those states is not a state party, the alternative way to express consent is for either the territorial state or the state of nationality to declare its acceptance of the court's jurisdiction ad hoc for a particular situation. And Ukraine is actually an example of that. I'll come on to talk a little bit about that in a few minutes. Let me get the sort of framework complete. And I hope I'm not losing you, but you'll be able to watch the recorded version of it in due course if you need to sort of work it through. The second requirement is there must be an exercise of one of three what we call triggering mechanisms, not the start of an explosive process, but the triggering of the initiation of proceedings in a trial. There are three ways that can happen, and any of them are valid alternatives. The first way is for a state party to the Rome Statute to refer the situation and to the prosecutor of the International Criminal Court, and by that act of referral, vest in the prosecutor the authority to commence a formal criminal investigation. The second mechanism is the UN Security Council making a referral. So the Council adopts a resolution, and by the same mechanism that applies to all UN Security Council resolutions, that is a vote of 10 members, no veto by any of the 5 permanent members, the Security Council can refer a situation. I already explained that happened in relation to both Darfur and Libya. It cannot happen in relation to Syria because the Russians have vetoed every attempt to refer the situation to the prosecutor, and it won't happen in relation to either Ukraine or Gaza. In the Ukraine case, the Russians would veto any attempt to do that, and Israel the US on behalf of Israel would veto any attempt to refer the situation to the prosecutor. So it's by other means in both those two situations that the prosecutor has the authority to open a criminal investigation. So state party referral is the first option, UN Security Council referral is the second. The third is the prosecutor acting on his own initiative and going to a pre-trial chamber of 3 judges and asking for their authority to open a formal criminal investigation. So he can't just go off on a whim of his own. There's a check and balance on the power of the prosecutor. But if he believes there are reasonable grounds, it's a pretty low threshold, but reasonable grounds for believing that Rome Statute crimes are being perpetrated in a particular situation, he can go to the pre-trial chamber and ask for their approval. The quickest they've ever given it is 3 months, so it can take some time, but it's there as an option, and there are a number of situations, including Georgia, Kenya, and I can't remember the third one, where that mechanism has been exercised. I said there were 3 requirements for a case to come to court. The first of them is consent. The second, one of these 3 triggering mechanisms has to be activated. The third is what we call complementarity. It's not a word that actually occurs in the Rome Statute itself. It's a word that's been coined to encapsulate the relationship between the ICC and the courts, the national courts of relevant states. So what this means is that the ICC only has jurisdiction where a relevant state is either unwilling or unable genuinely, the phrase in Article 17 of the Rome Statute, where a territorial state and the state of nationality are both either unwilling or genuinely unable to investigate the alleged crimes and try the individuals allegedly responsible for those offences. So if either state is prepared to do it themselves, they have a better claim on jurisdiction. So we could say, for example, that General Brereton in Australia, when he tabled his report, or the heavily redacted public version of the report of his inquiry into alleged ADF war crimes in Afghanistan, he made mention of the fact that the ICC has jurisdiction in relation to the situation in Afghanistan and therefore over the conduct of Australian Defence Force personnel. But under the Rome Statute, Australia has a better claim to national jurisdiction than the ICC, and we ought to exercise that. Mark Weinberg, who has been appointed to head the Office of the Special Investigator in Canberra, has said very similar things. Lord Justice Sir Charles Haddon-Cave in the UK, who's been appointed to conduct an independent inquiry into alleged UK Special Forces war crimes in Afghanistan, said exactly the same thing. The UK has a better claim to jurisdiction than the ICC. Let's exercise that and make sure we conduct a rigorous and bona fide investigation of the allegations that have been made. So they're the three requirements. The court must be satisfied of consent of one of the relevant states, must be satisfied that a triggering mechanism has given the prosecutor authority, has been exercised to give the prosecutor authority to investigate and to apply for the issuance of arrest warrants, and then the court must be satisfied that neither of the relevant states is exercising its national jurisdiction. Now, that's a formula, but obviously the ICC operates in an intensely politicised context. And the wars, I think, in both Ukraine and in Gaza are testament to what I'm talking about. The challenge for the prosecutor, and also for the judges actually, the prosecutor is the one who initiates things, the judges respond to what the prosecutor initiates. But the challenge for those key personnel of the ICC is to act on the basis, first of all, of the Rome Statute and the requirements that it contains, and secondly, on the evidence before them, and to operate openly, consistently, and as objectively as they can. And the contrast between, let's say, the Western world's response to the Ukraine situation and the support, the overwhelming support it offered and provided to the ICC, and the Gaza situation reveals how intensely politicised the context is. And like I said, the challenge is there for the prosecutor and the judges to see whether they're capable of rising above that to do the job that the court was created to do. That's, I think, enough. That's ICC 101. And there's plenty more granularity out there, but that's enough. Any questions, I'll be really happy to try and answer them. Let's move to the two situations. And what are some of the Rome Statute offences that have been alleged to have occurred? And here, I thought it might be just good to provide you an overview of allocations. I'm not revealing which of these are the priorities for investigation, either on the part of the Ukraine team or the Palestine team. I wouldn't be allowed to do that. I'm of course bound by confidentialities. I'm just trying to pick up on allegations that have been made in the media and in social media reporting of the two situations. What an auspicious and devastating day for the Ukrainians. Yesterday, the second anniversary, coincidentally, when Martin Reynolds and I first discussed possible dates and settled for me to come up here and speak, and we settled on 25th of February, I was not thinking about how proximate that was to the anniversary of Russia's invasion. But from the very start of Russia's war on Ukraine, there have been allegations of war crimes such as the bombing and shelling of cities and towns, the targeting of hospitals, schools and universities, the targeting of the energy grid, that targeting intensifying in the lead up to winter for the last two winters in Ukraine, the declaration of safe havens and of humanitarian corridors for evacuation of civilians, and then the sniping or shelling of civilians who are trying to flee through those designated corridors. The transference of Ukrainian children, sometimes orphans, not always, to Russia, and then changing of nationality, withdrawal of Ukrainian passports, the forcing of them to no longer speak Ukrainian, to not be educated in Ukrainian, but to become Russians. The blowing up of dams and the flooding of agricultural land, the use of starvation as a method of warfare by destroying arable land, by targeting food warehouses, by targeting food distribution centres, the execution of civilians in their villages, and the alleged torturing of prisoners of war, widespread rape and sexual violence against villagers and also against those held in detention. It's been overwhelming, and you will remember that from day one right through until October the 7th last year, the coverage of the Ukraine war was every day. And then all of a sudden, it was actually really difficult, at least in the Australian media, and I would say difficult in some of the international, Western international media, to find reporting of the Ukraine conflict after that day. I'm sure President Zelensky is really, really sensitive to that. It would be wrong to suggest that all the alleged war crimes are happening on the side of the Russians, and that's not the case. There have been allegations of torturing and summary execution of Russian prisoners of war by the Ukrainians, and we at the International Criminal Court must take seriously those allegations and also investigate them. And I think I can say without divulging confidentialities that we are investigating both sides of the conflict. In relation to Hamas, I mean, here there's one point of distinction to make, and it's really in relation to Article 8B of the Rome Statute. The court, I said, has jurisdiction over the international crime of aggression, which is the crime of unlawful use of lethal military force against another sovereign state. Now, unfortunately, in the case of Russia's invasion of Ukraine, the ICC does not have jurisdiction over that particular crime because the jurisdictional mechanism is slightly different to the other three crimes. So although the court has jurisdiction in respect of alleged acts of genocide, crimes against humanity and war crimes in Ukraine, it doesn't have jurisdiction over the crime of aggression. It's a pity because, in my view, the crime of aggression is the only category of crime that captures all the havoc and the devastation that's been wreaked upon Ukraine unlawfully. One reason why the International Court of Justice issued provisional measures against Russia, ordering them to cease and desist their military operation in Ukraine about 18 months ago, is because the International Court of Justice was convinced that this was an illegal war in violation of the prohibition on the crime of aggression. You can't say the same thing about the Israeli intervention in Gaza, because the International Court of Justice this time around, asked by South Africa to issue provisional measures ordering Israel to cease and desist its military operation in Gaza, the International Court of Justice weren't prepared to do that. And that's because there is a very widely held view in international law that Israel had the right to defend itself in response to the Hamas attack on October the 7th. But the way that it chooses to do that is really important. For me, for the alternative Prime Minister of this country to say on October the 8th, Israel can now act without restraint in response, was a disgraceful thing to say. How Israel goes about responding is absolutely and fundamentally important, and the war crimes of the international crimes of genocide, crimes against humanity and war crimes, the same definitions that we are applying in our investigation of the Ukraine situation also apply in the situation in Gaza. So, there are a whole stack of allegations in relation to Hamas conduct, that on October the 7th, Hamas fired more than 3,000 rockets indiscriminately into Israeli towns and villages, that they conducted murder, rape, the beheading of Israeli civilians, the mutilation of corpses, the looting and burning of civilian houses, and hostage-taking of more than 300 Israeli citizens. There are also allegations that Hamas hides its military headquarters and equipment under civilian residential areas in Gaza, under hospitals, under schools, etc., and that they fail to distinguish themselves from the civilian population when they engage in fighting. Not trying to justify these allegations or respond to them. I think it's enough to try and list some of them. To make all the arguments, of course, about how do you avoid doing that in an area that is smaller than Bruny Island. Gaza is 360 square kilometres. Bruny Island is 362 square kilometres. Imagine there are 1,000 permanent residents of Bruny Island. They get really shitty when 20,000 people turn up in the summer and there are big little queues for the ferry. Can you imagine 4 times Tasmania's population herded onto and quarantined on Bruny Island, and all the issues that would raise about massive dense population, sanitation, water, food, all those things. 500 trucks a day, they say they need to provide for the basic survival needs of 2.3 million people in Gaza, and 50 are making it through. It's an appalling situation. So I'm not sure exactly how Hamas distinguishes itself from the civilian population, but these are the allegations that have, some of them, I'm not trying to be exhaustive or comprehensive, some of the allegations that have been made. But against Israel, the allegations include that Israel has used starvation as a method of warfare by preventing the delivery of humanitarian aid and assistance, that they've engaged in disproportionate military force by bombing residential areas, refugee camps, hospitals, schools, universities, libraries, museums. We now know that in the north, Gaza City, and in the middle of, or the centre of Gaza in Khan Yunis, 60% of all buildings have been destroyed. Imagine that statistic. 1.9 million residents of Gaza are displaced, many of them multiple times actually, and Rafah in the south is now completely overwhelmed, and the threat is that when Ramadan starts, so will the intense military operation in Rafah. The forcing of Gazans to leave their homes and flee to the south, only to now be threatened with a military campaign. The engaging in looting and wanton destruction of civilian houses. So how does the international... Let me move to talk a little bit about the role of the International Criminal Court. How does the ICC have jurisdiction when none of Russia, Ukraine or Israel are states parties, and when the international legal status of Palestine is contested? Let me start with the Ukraine situation. Like I said earlier, even though Ukraine is not a state party to the Rome Statute, it has made a declaration accepting the jurisdiction of the court ad hoc. And it's done that back to 2014 when Russia invaded the Crimean Peninsula. So that requirement of consent by the territorial state is met as a consequence of Ukraine's acceptance of the court's jurisdiction. And under the Rome Statute, once the territorial state gives its consent, then the court has jurisdiction over all the conduct occurring on the physical territory of that state, irrespective of who the other players are and whether they've consented to the court's jurisdiction or not. The triggering mechanism that's been exercised is state party referral. Obviously, Ukraine, not being a state party, can't self-refer the situation in Ukraine, and it didn't. The prosecutor had two options, knowing that the third option, UN Security Council referral, is never going to happen. Russia would veto that. Prosecutor could have gone to the pre-trial chamber, acting on his own initiative, to ask for approval to open a formal criminal investigation, but he knew he'd have to wait 3 months or more for that approval to be given. So instead, the prosecutor put a call out to states parties to ask whether any of them would like to refer the situation in Ukraine. And in an unprecedented step, 39 states parties, including Australia, signed a referral, signed a document to give to the prosecutor authority to open a criminal investigation immediately. And he did that. He announced that that's what he was doing. In relation to the third requirement, the so-called complementarity requirement, there's no way Russia was going to investigate and try Vladimir Putin or any of the other senior leaders involved in decision-making in respect of the invasion and war on Ukraine. What Vladimir Putin has done is a claim on jurisdiction than the ICC, and we'll have to see whether that occurs or not. In the meantime, the prosecutor will proceed on the basis that he's investigating both sides. What about in Palestine? Despite questions about whether or not Palestine is a sovereign nation state, is created by a multilateral treaty, the Rome Statute, outside the UN system. The UN Treaty Secretariat acts as Treaty Secretariat for many multilateral treaties that are not UN bodies or UN treaties. So, same place, same process. Palestine lodged the instrument of accession in New York. And that notification was then sent out to all states parties, and only one of them, Canada, objected to Palestine's accession because Canada said, we don't believe or don't accept that Palestine is a sovereign nation state, so we don't think that they can become a state party to the statute. All the other states parties, including Australia, accepted Palestine's accession. And then subsequently, at the annual meeting of the Assembly of States Parties, that's a plenary body of all the states that have signed up to the statute. That's the governing body, that's the body that elects the judges, elects the prosecutor, sets the budget, approves the work of the organisation. The Assembly of States Parties endorsed Palestine's accession. So, arguably, the first requirement of consent was met. I'll explain how it was confirmed subsequently. In May 2018, Palestine, through the Palestinian Authority in Ramallah, self-referred the situation in Palestine to the Prosecutor of the International Criminal Court. They knew that the US would never allow a UN Security Council referral. That would be vetoed. So Palestine did it themselves as a newly minted state party to the statute. So the prosecutor arguably had authority at that point in time to open a formal criminal investigation. But the prosecutor at the time wasn't certain that if we invest all the resources, financial and human, into the conduct of a complex and protracted criminal investigation, what if, when it comes to the issuance of arrest warrants or further down the track in the process, a bench of judges, pre-trial chamber or the trial chamber, just says that no, court doesn't have jurisdiction because Palestine's not a state. So, under the terms of the statute, the prosecutor has the discretion to request of a pre-trial chamber of 3 judges clarification on jurisdiction. So that's what the prosecutor did. Just after receiving this referral from Palestine, the prosecutor then requested of the pre-trial chamber clarification on whether or not the court had jurisdiction in the situation in Palestine. And what we really mean by that is over conduct on the physical territory of Gaza, the West Bank and East Jerusalem. Pre-trial chamber, in response, took them a while. They were asked that question in May 2018. They answered in February 2021. How come it takes that long? I don't know. But anyway, February 2021, yes, the court does have jurisdiction. Without prejudice to the question, is Palestine or is it not a state in international law, for the purposes of the Rome Statute and therefore the court's exercise of its jurisdiction, Palestine is a state party to the Rome Statute. That's the only issue we have to decide, the only issue we have authority to decide. It's for the other court, the International Court of Justice, the World Court, the principal judicial organ of the United Nations, the court that's currently hearing the very case that the General Assembly has asked it to hear on the legal consequences of Israel's occupation of the Palestinian territories. That's a different court, and that's the court that can decide whether or not Palestine is a state in international law. Our job is to interpret and apply the Rome Statute. So on the basis of that decision, the prosecutor thought, right, we have consent, we have the effective triggering mechanism, we can now proceed to a formal criminal investigation. A formal criminal investigation was opened, and in relation to complementarity, there's no evidence that Hamas is willing to investigate itself or its own members. And on the Israeli side, despite the fact that Israel claims it has a robust military justice system, that military justice system has not been evident. If you want a glaring example, in my view, of how lacking in robust and rigorousness it really is, the trial of Elor Azaria, the young IDF medic who at point blank put a couple of rounds from his automatic rifle through the head of a Palestinian guy lying wounded in the streets of Hebron. He was charged by the military advocate general with murder. I don't know how it could be anything else. He was captured on on mobile phones of dozens of people who were witnesses to it, and I think that's the reason an investigation followed. He was charged with murder. The government intervened, said that's completely unacceptable. This guy's a hero. It was downgraded to manslaughter. He received 12 months, six of them suspended, the other 6 months under house arrest. It's not a military justice system that is committed to accountability for egregious violations of the law of war, in my view. So, I mean, that's up to the court to decide whether Israel is unwilling to investigate its own personnel, but there's not much evidence of it right now. Okay, let me try and wind up. What is the International Criminal Court doing right now, and will it have any practical effect? There have been, as many of you will know, arrest warrants issued against both Vladimir Putin and Maria Lvova-Bulova, his children's commissioner in Russia, for the war crime of deportation of Ukrainian children to Russia. That arrest warrant, reflecting the first crime to be investigated by the Ukraine team at the ICC, those two arrest warrants were issued in February 23. And although the detailed content of them has not been made public, the court chose to identify publicly the two accused and also the crimes, the substantive crimes, on the basis that that might act as some sort of deterrent to Russia continuing its military campaign in Ukraine. It hasn't. I don't think you could say on any measure that the ICC issuance of arrest warrants have had any deterrent effect. So what's the point of them? What's the point of issuing them? And when there's no short to medium term realistic prospect of Vladimir Putin being arrested and tried in The Hague? And what's the point of making them public? Well, interestingly, so in response to that question, which I think is a totally fair enough question, first thing I'd say is that Vladimir Putin is restricted in where he can travel now. South Africa hosted a BRICS summit, the Brazil, Russia, India, China, South Africa grouping of states. There was a head of state summit in South Africa late last year, and we at the court were watching very closely because South Africa is a state party to the Rome Statute, and you know South Africa's taken a big public position in relation to Gaza about the importance of rules-based international order and the enforcement of international criminal law. Is he going to go to South Africa, and if so, they're going to arrest him, or is he not going to go? I suspect the South Africans had a big chat virtually, or maybe through the embassy in Pretoria, and said, please don't come because you'll embarrass us. And he didn't. He chose not to go and sent his foreign minister instead. So he's restricted in where he can travel. It'd be fair enough to say Russia's the biggest country on the planet. He's got plenty of options about where he goes, just not as many as he might once have had with 123 states parties to the Rome Statute. Is that enough? Well, there are sanctions against him and against his leaders and oligarchs. No obvious deterrent effect from those at the moment. In response to, what are the chances of him ever being arrested and taken into custody and tried? No time soon, don't hold your breath. But for me, the precedent of Slobodan Milosevic is really important. The arrest warrant against Putin and against Maria Lvova-Bulova are both for life, for their lives. There's no statute of limitations that imposes some time limit on when the ICC has to conduct its trial proceedings. As long as either or both of them are alive, the arrest warrants against them are valid. In the case of Slobodan Milosevic, the arrest warrant was issued against him by the prosecutor of the Yugoslav tribunal in 1993. He was well entrenched in power in Belgrade. There was no obvious prospect he'd ever be taken into custody. In 1999, when he decided to conduct an ethnic cleansing campaign of the northern parts of Kosovo against Kosovo Albanians, he lost, and the West responded this time with lethal military force, NATO bombing of Kosovo and also of Serbia. This time around, he was voted out of office. Many people in Serbia thought he's taken us back into war again, and he lost power. And the incoming government was told, if you want what it was, $2 billion US in aid to rebuild the country that we've just destroyed for you, you have to hand over Milosevic. If you want a pathway to EU membership and integration into Europe, you need to hand over Slobodan Milosevic. And so they did. He was handed over in late 1999, 2000, and his trial commenced in 2002. I'm not suggesting that that precedent will necessarily play out in the same way against Vladimir Putin, but for me, you can't really say there's no chance he'll ever face justice. Maybe he will. One thing's for sure is that there's an ongoing investigation and there will be further arrest warrants issued. I can't honestly say why there haven't been more arrest warrants. I know that there are several that are close to being finalised, and the process for issuing them is for the prosecutor to go to the pre-trial chamber, lay out the evidence and establish reasonable grounds for believing that this individual accused is responsible for these alleged Rome Statute offences. It's again quite a low threshold, but has to be met, and the judges decide then whether to issue the arrest warrant or not. I expect that there will be more applications for arrest warrants in the Ukraine situation in the coming months. What about arrest warrants in relation to Gaza? Given that the first arrest warrants in the Ukraine situation took 12 months, I think it's probably unlikely that we could expect arrest warrants in the Gaza situation in the next days or weeks, but I think that there definitely will be sometime this year, and that, like the Ukraine situation, the Office of the Prosecutor is committed to investigating both sides of this conflict and the allegations of Rome Statute crimes on both sides. What else is happening? What would be the effects of an arrest warrant against Benjamin Netanyahu or other members of his cabinet, against the Minister of Defence, Yoav Gallant, or some of the other ministers who've been saying some outrageous things about destruction of the population of Gaza? Itamar Ben-Gvir and Bezalel Smotrich seem to me to make Israeli leaders that I thought were out there in terms of their pretty extreme views look almost reasonable. Well, we're seeing a massive erosion of Western support for Israel as a consequence of the conduct of the current military operation. I've never seen anything like it before since the creation of the State of Israel in 1948. The International Court of Justice is being overworked by their standards in terms of the Gaza situation, with a case that South Africa brought pursuant to the Genocide Convention a few weeks ago, and now last week and again ongoing this week, the request from the UN General Assembly for an advisory opinion on the legal consequences of the occupation in Palestine. I think if the ICC added to that growing building of consensus against the way Israel's gone about its military operation, that would have more politically damaging consequences. Benjamin Netanyahu would have fewer places to travel. Israel's 1/3 the size of Tassie. They've got a few resorts in the south and along the Red Sea, but yeah, he won't have quite the options of the Russian president, but I don't know. I think that it will be incredible, the fallout from that. We'll have to see what happens. The expectations, of course, are so high from many people, many governments, and diametrically opposed by others who have a different view. One question I want to finish on is, what's the effect on the normative legal framework when we say we're committed to an international rules-based order, we're committed to the law of war, law of armed conflict? What's the effect on it when it's being subjected to egregious violation on a daily basis? And what's the role of the International Criminal Court in respect of all of this? It seems to me that one of the contributions that the court has made so far, apart from the cases that it's decided apart from the decisions that it's made to build the case law, the jurisprudence of the court in relation to this body of law, that there is a reality about the spectre, if I can call it that, the spectre of the ICC as an incentive on states to take national responsibility for investigations of and trial of war crimes much more seriously. And I don't think we can explain the Australian response to allegations of SAS war crimes in Afghanistan, or the British response. We can't explain it any other way. Neither country or neither individuals involved in the processes in each country would say that's the sole explanation for why we're taking this more seriously than we might have done previously when allegations have been made against our own armed forces. But both, as I said before, all of Major General Brereton, Mark Weinberg and Sir Charles Haddon-Cave have all publicly said we need to take this seriously and be seen to be taking it seriously. Now that's, I think, a positive thing in terms of the court and complementarity. But here I'll finish up. Come back to this comment I made earlier. For me, there's a massive challenge for the ICC in relation to Gaza. Court's under intense scrutiny to see if the prosecution and the judges, the prosecutor I should say, and the judges will act consistently, will interpret and apply the provisions of the Rome Statute fairly and objectively. I mean, states have actually acted inconsistently with the overwhelming response of offering millions, hundreds of millions of euros and US dollars to investigate Russia, the secondment of dozens and dozens of experts to the Ukraine investigation team at the ICC, and not anything approximate to that in relation to Gaza. But the institution of the court and the key people that make it happen, they have a huge challenge, and we'll have to see whether they are up to responding to it or not. Thanks very much.
So, from the floor, any questions, please? Yes.
I enjoyed the talk. I don't normally make that sort of preface, but I like this detail and I like the structuring of the detail. So I'm also an academic. I appreciate it. Go back to the general concern about organisations such as this, about practical effect that they can have on, in effect, recalcitrant state and non-state actors who are doing nasty things. Yeah, there's a sort of a public shame effect, and yes, you can't travel effect, but take a rogue state actor like China. China's just going to wave a chosen set of digits in your direction. Take a rogue non-state actor like Hamas, who I hope are being put on the griller too. It seems to me that the International Court could say whatever it liked and again would just receive a chosen set of digits in its direction. So going forward, how can that be remediated? Is there any way of bringing more state actors into the fold, and is there any way of improving the teeth of sanctions upon non-state actors like Hamas and state actors like China?
So the question is concerning how effective can the ICC be in executing its responsibilities in investigating and prosecuting. Would that be?
It'll do.
Yeah, it'll do.
It'll come out in the response on the recording anyway.
Let me start with the preface, because in all the times that you come to one of my presentations and ask a question, you've never started off like that.
I like this better than the last one.
Yeah. So I take that as high praise, and I thank you for it. It's a very generous comment. But it's a really good question, and I'm grateful for it. Because for me, the sort of observation about how the ICC is a natural progression should really be tempered with the reality that it's far from representative of a comprehensive and systematic system of international justice. It is not. And the fact that China, three permanent members out of 5 of the Security Council, China, Russia and the US, are not state parties. And even for those 2 that are, the UK and France, you can forget any possibility that the UN Security Council will refer any situation that involves vested interest on one or more of those 5 permanent members. So there will be no referral of US military commissions in Guantanamo Bay, there will be no referral of Tibet or anything else that China gets up to, no referral of Myanmar in fact, because China has prevented that. It just happens to be coincidentally the case that when the Rohingya were forcibly displaced from Myanmar across the border into Bangladesh was a state party to the Rome Statute, and so the international crime of deportation happened partially on the physical territory of a state that had already expressed its consent. But that's a sort of happy coincidence. It's not a principled solution. So I think, I've said this many times in the past, but I didn't today, and perhaps should have, that for me, while I obviously support the work of the International Criminal Court, I wouldn't have spent 14 years of my life working for 3 successive prosecutors otherwise. I accept that this is not yet as strong as we want it to be. I don't think there's any incompatibility with being committed to this as the best that currently exists, but also recognising and working for and urging a more robust, comprehensive and systematic system. So I absolutely accept that, and try and make sure my students understand that. I'd also say, in response to the issue, the question of the recalcitrant non-state armed groups, the ones who aren't going to abide by the rules anyway. Hamas is not alone. Hamas is sort of representative, if you like, emblematic of many other organisations participating in armed conflict that don't give a stuff about the limitations to how war is conducted. My answer to that is, it's very frustrating, but we in the West need to insist that our armed forces nevertheless comply. It's a very easy thing for military to say, well, if they're not going to abide by the rules, why the hell will I? And I was at Anglesey Barracks on Tuesday night to a military audience on a similar subject matter, and got a little bit sensitive for some of them when we're having this sort of conversation. But I believe very strongly in it. If it's okay for special forces to be beyond the law because the Taliban are a bunch of ratbags, and why would we fight with one hand behind our back, figuratively speaking, then we are on a slippery slope to no holds barred, to military hospitals being targeted all the time instead of only some of the time, to no rules applying, and I'm not prepared to advocate for that, even though I can listen to an infantry colleague who tells me that, this is what you're saying is very impractical. Maybe I've got the benefit of being an academic and not on military operation, but I wouldn't, I'm not prepared to let go of that commitment.
Good.
Peter, did you want to have a follow-up?
Well, it was just an element of my question didn't get addressed. Incidentally, I'm an ex-infantry sergeant, so I can sort of feel both there. So how are you going to make, or how do you think it's best for us to increase the robustness of the institution?
How do you think it's possible for us to increase the robustness of the institution?
For me, international criminal law 4.0 would be a system that is compulsory jurisdiction, mandatory, and that requires a significant diminution of state sovereignty. So maybe in the future, the existential threat of climate change destroying the planet, which subsequently drives a new acceptance, albeit reluctantly perhaps, that we've got to let go of some of that. Maybe that's what will be the great catalyst, I'm not sure. But I can't see it happening any other way. Where one state that has greater level of military, political and economic influence in the world is able to say, well, it's fine for everyone else, but it doesn't apply to me. Well,